afternoon and welcome to the Court of Appeals. Take just a few moments and talk about our procedure before we get started. I'm sure that many of you have been here before and understand how we operate, but each side will get 15 minutes to make its oral argument. If you are the appellant and you wish to reserve rebuttal time, you may do that by after you've come to the podium and introduced yourself, but before you begin your argument, requesting that from the court. You may reserve up to 5 minutes of rebuttal time. If there are more than one attorneys or people who are going to argue, you would need to share that 15 minutes time, and you'll need to decide how you're going to share that and announce that to the court so we can set the timer. Excuse me. There's a timer on the podium. We believe it to be very straightforward. It has 3 lights on it: green, yellow, and red. Long as the light is green, you've got plenty of time. Once the light turns yellow, you're running out of time, and once the light turns red, you're out of time, and we ask that you please respect those time constraints. One other thing that's very important, all these arguments are being live streamed, which means as soon as you say whatever you're going to say, it's going out over the internet. So just think about that before you say it. Let's see. Let me introduce our panel for this afternoon. Judge Kenny Armstrong from Memphis, Judge Valerie Smith from Memphis, and I'm Steve Stafford from Dyersburg. Miss Angie, anything we need to take up before we get started?
No, Your Honor.
You may call the first case then.
Amanda Cooper Hearn as trustee of the Cooper Family Trust versus Sharon Thomas as trustee of the Cooper Family Trust.
May it please the court. I'm John Little from the Madison County Bar, and I represent the appellant, Miss Sharon Thomas, in this matter. I respectfully request the court to assist with the keeping of time today. I would like to reserve 2 minutes for rebuttal.
2 minutes, all right.
I'd like to start by giving the court just a little bit of factual background before we get into the argument. This matter arises out of a trust that was established back in 2011 by Edwin and Mary Cooper. Mary Cooper subsequently died, and after she died, there were 3 amendments to the trust, as well as the execution of a pour-over will by Mr. Edwin Cooper. He died on February 15th of 2017, and his daughter, my client, Ms. Thomas, was designated as his personal representative. The trust that we're here about today was the devisee of all the estate assets, and all the estate assets were devised to the trust. There were 2 co-trustees of the trust, Ms. Hearn, who's the appellee, and Ms. Thomas, the appellant. Each of those persons signed receipts so that all of the estate assets poured over into the trust. The 2 persons acted as co-trustees for a period of about 3 years. When there began to become some disagreements between the 2 of them. And they both consulted with an attorney here in Jackson, Mr. Will Bell, about how to try to wrap this up and what to do with some possible contingent beneficiaries. He suggested that there was a rule against perpetuity problem with the trust, and there was also some potential risk as it related to some potential qualified beneficiaries. He suggested that each person get separate counsel. Ms. Thomas hired Wes Clayton from our firm, who has subsequently retired, and Ms. Hearn hired Donald Glenn, who's opposing counsel here today. This case is complicated from the standpoint that there are 2 lawsuits that were existing simultaneously. The first lawsuit is this lawsuit. It was filed on September 3rd, 2021, and it basically involved a malfeasance claims between the 2 trustees. There was an answer and a counterclaim, and so each of the parties alleged some malfeasance on the part of the other as co-trustees. There was also a declaratory judgment action which was filed on November 5th, 2021, about a month or so after the case at bar was filed. And that case involved the interpretation of some of the trust materials as it related to the rule against perpetuities. The parties agreed to stipulated facts and procedure, and the declaratory judgment action, was resolved prior to this particular case. After the declaratory judgment action was finished and over the objection of Ms. Thomas, the trial court granted a motion to amend the malfeasance or injunction suit that we're here about today in order to assert a no contest clause. We're here on what we believe to be 3 issues on appeal. 2 of them are procedural and 1 of them is substantive. The 2 procedural issues are whether the trial court erred in granting Ms. Hearn leave to amend this injunction lawsuit in order to assert a claim for the no contest clause. And the other procedural issue is whether the trial court erred in denying the motion to alter or amend the summary judgment, partial summary judgment granted on behalf of Ms. Hearn as a result of the no contest clause. And then the final issue is a substantive question of whether the trial court erred in granting partial summary judgment to begin with by failing to apply the safe harbor provisions of Tennessee Code Annotated Section 35-15-1014.
And under the facts here, which provision do you think this falls under in terms of the safe harbor?
I believe that this falls under the safe harbor provision in reference to the construction and interpretation. The statute specifically states that any action brought by a beneficiary or on behalf of a beneficiary for a construction or interpretation of the terms of the trust is entitled to the safe harbor provision.
In your complaint for declaratory judgment, do you simply ask for an interpretation of the trust, or do you go further and ask that certain provisions of the trust be invalidated?
There were allegations in that declaratory judgment action in reference to the invalidation of certain provisions. However, if the court looks at the total context of the claim between the 2 parties, as well as the other pleadings that were taking place between the 2 parties, it really came down to a question of which version of an amendment applied. And so although the technical wording of the complaint may have been or may have included the words invalid, the gravamen of the complaint was for a construction of the trust. And we also it must be added that there were 3 potentially qualified beneficiaries that needed to be dealt with as well at the time of that declaratory judgment action. And so it's very clear that both Ms. Hearn and Ms. Thomas had differing versions of what they felt like the trust should have been. And it's also very important to realize that although there were some technical words regarding invalidity, if you look at the complaint as a whole, and especially when you look at the request for relief, there is a specific allegation that says this complaint seeks declaratory relief as to the proper interpretation and rights of the trust. Before we get to the safe harbor provision, we believe that the trial court should not have allowed Ms. Hearn to even amend her complaint. We believe that, granted, the trial court has very broad discretion to allow an amendment of a complaint. We recognize that. But in this particular case, we don't know what factors the trial court used in exercising his discretion, or if he used any factors at all. We do know that there was a motion. We know that there's a response. We know that there was a hearing. Ms. Hearn argues in her brief that the mere fact that there was a hearing means that the court must have considered the appropriate factors. That may or may not be true. Our problem is that we can't know what factors the court applied because there was no wording as to the court's determination.
What do you say the court, or what is the obligation of the court in explaining its decision?
Well, a court simply rendered a decision. And, we believe that the court has to use a detailed analysis. We believe that the case law says that there must be a detailed analysis. Now, we don't have any written order from the court to know what his analysis was. And so that's the reason why we believe that if we look at this now, even in retrospect, applying the standards now would show that there was an abuse of discretion in allowing the amendment.
I guess what I'm asking more specifically is what rule are you relying upon that says the trial court has got to provide you with its thought process in determining whether to grant or deny the motion?
I don't know of any specific case law that says that the trial court has an obligation to do exactly as what you're asking me about. I do know that the case law says that the trial court must analyze certain factors. And now, I also know that although a trial court has very broad discretion, that discretion is not immune from appellate review. If that were the case, then there would never be, if there is an assumption that the amendment is appropriate, or that the trial court exercised its discretion appropriately simply because there was a hearing and an order, then we would never be in a position to have any type of meaningful appellate review of any decision. So even if there's not a requirement that the court spell out its reasoning or its factorial analysis of its decision on the motion, the court is not immune from our taking a look at it now and determining whether there was it would be an abuse of discretion.
Well, how do we do that?
We look at it.
Because you've said that you don't know how the trial court analyzed it. So what do we look at here?
We look at the factors now. There are several factors that a court must look at when making a determination on how it wants to exercise its discretion. Case law says, there are basically 6 factors. We believe that there are basically 3 of those factors that would preclude the granting of the amendment or would show that granting the amendment is an abuse of the discretion. We believe that there's undue delay. We believe that there's lack of notice. In this particular case, we've got 2 lawsuits going on simultaneously that involve the same 2 parties, and we believe that the appropriate venue for any of those claims that related to a so-called declaration or an interpretation of the trust should have taken place in the context of the declaratory judgment action, especially in the way in which the 2 parties moved forward to resolve the declaratory judgment action.
I noticed in your brief, you try to make the point that the appellee joined in the complaint for declaratory judgment, but I'm trying to figure out why would the appellee do that? Because what you requested in the complaint for declaratory judgment, you requested that the Second Amendment be considered to be invalid. And under the terms of the Second Amendment, the appellee stands to gain more than if the trial court had determined that that provision was invalid. And the only person who would receive more would be your client. So why would the appellee join into that as you suggest in your brief?
Was there an express agreement? No. Did the parties work together through counsel in order to develop a method and procedure to resolve the issue? Yes. And so that's how that all worked out. We believe that's part of the undue prejudice in this, because had our client known that there was going to be an issue as it related to the no contest clause, then they would have pled differently. They would have not agreed on certain procedurals. procedures for the resolution of the claim, would have called witnesses, and could have amended pleadings appropriately.
Yeah, let me ask you one other thing. In your opposition to the request for the amendment, you knew, I assume, from the amendment that was attached to the motion to amend, that they were going to raise the no contest provision of the trust.
Correct.
At that time, did you argue that that was a compulsory counterclaim?
Mr. Clayton was at that time, and I can't answer that with certainty, but I do not believe in all candor that he did.
Okay, so that would be waived then?
Well, I don't know that it would be waived, and the reason why I don't think that it would be waived is because of the court's finding in terms of the date of the trigger. The court, although that may have been an allegation that was going to be attached to that amended complaint, there was no determination as to when that no contest clause was triggered. And as a result, there was no way to identify whether that was going to be an affirmative defense or a compulsory counterclaim.
Okay.
Thank you. You've still got your rebuttal time.
Good afternoon, Your Honors. My name is Donald Glenn, and I represent Ms. Hearn. This appeal concerns the enforcement of a no contest clause that was contained in the Cooper Family Trust. The Cooper Family Trust was a revocable living trust that was executed by Mr. Edward Cooper and his wife, and the particular section of the trust that was subject to the challenge of the appellant was the Second Amendment to the trust, which was executed by Mr. Cooper in 2016 at a time when his wife had passed away. If successful in the challenge, my client would, if the appellant was successful in the challenge, my client would have been removed as a primary income beneficiary of the trust and reduced to the status of a life tenant with certain real property, while the appellant would have received in fees some certain real property and would have been established as the primary residuary beneficiary of the trust, subject to some small income payouts to other beneficiaries.
You're talking about the deck action.
Yeah, that's exactly right. That's exactly right. And in that, the appellant asserted that the Second Amendment to the trust had no residuary beneficiaries listed. In the what he did in the Second Amendment was he deleted in entirety Article 3 of the trust, which was the dispositive provisions in the event of the death of the grantors. And in the Second Amendment, it doesn't specifically provide for residuary beneficiaries or a termination date for the trust. And so the appellant challenged that on rule against perpetuities grounds. And she asked the court to hold that that Second Amendment was invalid and of no effect. In doing so, in putting forth that argument, the appellant ignored certain other provisions of the trust, Article 15th of which had a rather garden variety savings clause, which provided that at the time of 21 years after the death of the grantors and any existing beneficiaries, that the trust should terminate and that the income and principal of the trust should be distributed to the then inexistent income beneficiaries. I think it's important for this court to know that in that declaratory judgment action, the appellant did not go to the trial court and say, look, we think there's some confusing language here in Article 3, and we're not sure how that language works with the rest of the trust, with the savings clause. Court, could you tell us who the beneficiaries are? And could you tell us when this trust is going to terminate? What they did in their declaratory judgment action was, under their causes of action, after they repeated the facts, they said the Article 3rd and the Second Amendment Article 3rd are invalid and violate the rule against perpetuities, as there are no provisions for termination of the trust. They asked for relief that's into the causes of action, holding that the Second Amendment of the trust is invalid and of no legal effect, and further holding that the original trust, combined with the First Amendment, is the legal and effective trust. And then in the prayer for relief, asked for a holding that the Second Amendment was a nullity and invalid as against Tennessee law. So if I can kind of set that context for your honors, at the time that this challenge was filed in the declaratory judgment action, what we have in the trust is the original trust and the articles that were changed in the Second Amendment, because the Second Amendment refers to specific articles, deletes them in their entirety, and replaces them with the language in the Second Amendment. So what the appellant was wanting to do is find that that language in the Second Amendment made only the Second Amendment void. But what really should have happened if the appellant had been correct was the whole trust should have been void, because the First Amendment doesn't exist anymore. It's been, the dispository provisions in the First Amendment have been deleted, right? So what the appellant was asking to do was to have the court invalidate a portion of the trust, resurrect a section that the grantor had deleted himself with his own intention, and bring that back, and that just happened to be to her benefit and to the detriment of my client. The court said no. The court said, wait a minute, this trust is valid. Yes, you're right. The Second Amendment doesn't have these provisions, but if you read the rest of the trust, it clearly does. And so the trust and the Second Amendment was held to be valid. At that point in time, when that ruling comes down, we move to amend our complaint to assert the no contest, to enforce the no contest provisions of the trust. And after that was briefed and argued, the court agreed that the no contest provisions were triggered and that there were no exceptions.
Was there any discussion about this being a compulsory counterclaim?
No, Your Honor. The first time that compulsory counterclaim was ever raised has been in the appellant's brief on appeal. It was not raised at any point, whether it was at the motion to amend stage or the motion to alter or amend stage, or throughout any of the briefing of the motion to dismiss, the motion for partial summary judgment, or the argument that supported those.
And let's talk about the trial court granting that motion. Opposing counsel suggested that there apparently trial court granted it without any explanation. Can you explain that any?
I don't know of any rule that requires the trial court in granting a motion to amend to list the facts upon which it based the ruling, or to spell out its analysis, so to speak. But I can tell you that motion to amend was filed, and it was opposed, and it was argued. And there were two grounds that were raised at the trial court level to challenge our motion to amend. As the court's well aware, 1501 provides broad discretion to the courts to amend pleadings. Relief is to be freely given if justice requires, and it's only to be overturned in an abuse of discretion. At the trial court level, the only two challenges to the motion to amend were futility and the undue delay. I'm not going to address the futility at this point in time because I don't think that it's relevant, but the motion to the undue delay was that it had been a year. My office files the original lawsuit, this lawsuit, alleging trustee malfeasance against the now appellant and asking for an accounting and injunctive relief. They countersue us. They answer and countersue alleging trustee malfeasance on my client's part. A couple of months later, they said, hey, we think this Second Amendment's invalid, and we're going to have it thrown out. So they filed the declaratory judgment action, and it proceeds along at that time. As soon as the declaratory judgment action order was entered, our office set about to amend the complaint to enforce the no contest provisions. I did not think then, and I do not think now, that if we had lost the declaratory judgment action, and the court had ruled, the trial court had ruled that it wasn't that Section 2, Amendment 2 was invalid, and they granted the relief that they granted to the appellant, that we would have been successful on a no contest claim, that we would have had any hope of prosecuting a no contest claim. So in that case, we filed it as soon as that order was entered. There's no situation here where we have a statute of limitations that we're trying to relate back to. We don't have any evidence that's now missing. We don't have witnesses that have passed away or who are outside the breadth of the reach of the court. We don't have any of those changes. We don't have new parties. We had the exact same judge. We had the exact same court in existing litigation that concerned the actions or inactions of them as trustee, which is exactly what this no contest claim is, the actions of the appellant in trying to have the trust dissolved. We urged the court then, just as we urge this panel now, that there was not undue delay, and the court agreed with that. The court granted our motion, instructed our office to prepare the order, which we did. So I do agree that there was not as you might do for a motion for summary judgment, there was not this exhaustive analysis, but it was a Rule 1501 motion to amend a complaint.
Let me ask you, if the trial court had denied the request to amend the petition, would you have had a right, and in that order doesn't set out any analysis as a basis for denying the amendment, would you have had a right to appeal that and cite to the fact that the trial court provides no analysis for denying our motion to amend the petition?
I don't think I would, Your Honor. I think I would have a right to appeal, but on appeal, I think I would have to argue what's being offered, what was argued there and what's being argued now. I don't think the simple fact that the court did not spell out the facts upon which they based an order for a motion to amend would have given me an independent cause for appeal. But certainly the court could consider whether or not it appears, based on the arguments that are being made today, whether or not there was an abuse of discretion.
But unless the court sets out something in the order, what is there for us to review? I mean, we know what conclusion was reached, but we don't know why the court reached that conclusion, which is the case here. We don't know why the court reached the conclusion to allow the amendment, since it was opposed on several grounds, not just two, but on more than that. From my reading of the briefs, and also from having looked at the opposition to the request to amend.
The only things that I recall, Your Honor, with regard to the initial complaint, the initial challenge to the motion to amend was futility or undue delay. They did come back under the motion to reconsider and alter or amend and add a claim for a claim preclusion that was not argued initially, but that was argued on that Rule 59 motion to amend. So I do think, and I believe that it is listed in the pleadings that were filed. I think those are of record in the appellate review, but Your Honors can certainly verify that. But I do think you can make an argument based on those factors today that you could decide whether or not it appears that there was an abuse of discretion in granting that motion.
The claim preclusion, I assume that goes to the compulsory counterclaim?
Well, it didn't at the trial court level. Nobody ever alleged at any point that there was a compulsory counterclaim to the declaratory judgment action. What happened in that regard, Your Honors, is once we were allowed to amend, they filed an answer, they filed a motion to dismiss, we filed a motion for partial summary judgment asserting the no contest claim. Both the motion to dismiss and the motion for summary judgment were argued and briefed together at a hearing, and claim preclusion is a res judicata argument. It's a defense, an affirmative defense that's supposed to be raised in the answer. It was not. If not raised in the answer, sometimes it can be raised under a motion to dismiss. It was not. This was not just a motion to dismiss that like every defense lawyer throws in there but never argues. They briefed and argued this motion to dismiss, and they never once mentioned res judicata or claim preclusion. The only time that it got mentioned was in the Rule 59, a motion to alter or amend. There was never a motion on the part of the appellant to amend their pleadings to add that claim. It was only argued on that motion to reconsider. And at that point in time, Your Honor, I think it was clear that it wasn't appropriate. It had been waived. Even if it wasn't waived, this isn't claim preclusion, all right? Even if it wasn't waived. The appellant has asserted the federal standard, which is the MIGRA standard. It requires a final judgment on a prior action and a subsequent suit. We don't have that here. This action's prior. This action's not a subsequent suit. And the lawsuit has to be from the same transaction. Well, it's not from the same transaction. The transaction in the declaratory judgment action is the act of the trustor in creating that Second Amendment and the language that they used and their assertion that that invalidated that Second Amendment. In the no contest claim, it arises not from the actions of the trustor, but from the actions of the appellant in challenging that lawsuit. These are not the same transaction under the MIGRA analysis. Now, I couldn't find, and I say I couldn't find, my associates could not find, any case in Tennessee where MIGRA was actually supported. There is, under Tennessee claim preclusion, Jackson versus Smith is a 2012 Tennessee Supreme Court case, and it says that claim preclusion bars a second suit between the same parties if the court had jurisdiction, and both claims are asserted, the same claims are asserted in both, and the first judgment's final. Here again, I don't think it meets the Tennessee claim preclusion standard. We had additional parties in the declaratory judgment. We don't have the same claim. It's not a second suit. Even if it wasn't waived, this is not claim preclusion. Even if your honors believe that the compulsory counterclaim was somehow raised at the lower court and shouldn't be barred at this court, it's not a compulsory counterclaim to that declaratory judgment action. Rule 1301 provides that for a claim to be a compulsory counterclaim, it has to arise out of the transaction or occurrence that is the subject matter of the opposing party's claim. It does not say it has to arise out of the opposing party's claim, because that's what it did. It's the same, it dovetails nicely with the argument on the claim preclusion, because this is not the same transaction or occurrence that created the no contest claim that created their attempt to invalidate the trust.
Was the first attempt to invalidate the trust the complaint for a declaratory judgment? Did that happen also in the answer and counter to the petition for injunctive relief?
I think that you can say that a not fully fleshed out attempt at that. There were certainly signals in that answer that suggested that they wanted to do that. Yes, Your Honor.
So you really didn't have to wait until the trial court decided the complaint for declaratory judgment to file your no contest, did you?
Well, with that argument, I mean, the question would be whether we had to, if that's true, if we were required to do it then, well, you could argue that we were required to do it then, or that we were required to do it the day they filed their declaratory judgment action claim.
Well, no, I'm asking about the answer and counter, in which they say that the amendment was invalid. They say that in their answer and counter petition for injunctive relief.
Yes, and I understand that. They certainly do. I can tell you that my opinion then and my opinion now was that if they had been successful in that claim, that we would not have been successful in our no contest claim. I can tell you that without equivocation. I think there is some support for that in the law that I've argued in the brief, simply because under the old law, if there was reasonable justification for a contest, then the no contest clause was not enforced, and that when TCA 3515-1014 was enacted, while it did change that rule, it did not expressly provide that successful challenges could still be prosecuted under no contest claims. I don't think we would have been successful doing it. I don't think, and we didn't raise it at that time on those grounds.
Okay.
I have 22 seconds. I will try to
Going the other way.
I have no seconds.
That's right, you're going the other way.
I'm sorry.
That's all right, that's all right.
Thank you, Your Honors.
Thank you.
Thank you, Your Honors. Just to respond to a couple of the questions of the court, part of the problem in this case is the fact that we have a ruling from the trial court, a specific ruling from the trial court that says the filing of the declaratory judgment action triggered the no contest clause. We couldn't know that. We couldn't know that the trial court was going to rule that the mere filing of the declaratory judgment action triggered the no contest clause until the court ruled that. And after the court ruled that, we raised that in a motion to alter or amend, citing the court's own statements, the own ruling from the court as to the date of the trigger. And this also shows the problem that we have in this case as well, and that is, well, what would it matter if the no contest clause was triggered at the filing or at the successful conclusion of the declaratory judgment action for the appellee? Well, here's why it makes a difference. It's because the statute doesn't say that you have to have a successful resolution of a no contest clause in order to plead it. It doesn't say, the statute says any action to invalidate a portion of a trust triggers a no contest clause, not any successful action as the appellee would have us believe now. And that is the reason why claim preclusion became a big issue in the Rule 13 compulsory counterclaim. Now, although the words Rule 13 compulsory counterclaim were not used at the time that we raised the claim preclusion issue, it's one and the same. They exist coextensively together. And the question as to whether or not the factors for claim preclusion apply, we have the same parties. We have the declaratory action where the no contest clause is supposedly violated. That's actually being raised in the subsequent action where it should have been raised, where it was supposedly triggered. And we believe that all of the criteria for claim preclusion are applicable. Thank you, Your Honor.
Thank you. Thank you, gentlemen. We will take this matter under advisement, review the record, and attempt to get you an opinion at the earliest possible time. Thank you. You may be excused. Miss Angie, if you'd call the next case, please.
Robert W. Smith et al. Versus Maxie Jones, DB